Hi, everyone, and welcome to today's fifth episode of our webinar series on the basics of the PCT. It's wonderful to see you come back, or if you're new to this, it's also very nice that you were able to join us today. My name is Matthias Harsche-Park. I'm Deputy Director of the PC Legal and User Relations Division, and it's a real pleasure to have you here with us today. Thanks for Paola, who's working behind the scenes to make this all possible and has set up today's event for you. As usual, I will start out with giving a little bit of a presentation. And as I move along, you can type in any questions that you might have into the Q&A part of this Zoom tool. And I will try as much as I can to monitor the incoming questions, and then we'll have time to answer them. If by some chance we don't get round to answering all of them, the questions you have typed in, we can then still send emails back to you with answers. If you didn't get around to asking any questions, you can always address your questions to PCT. Oh gosh, which one is it? PCT.learning, I think, at WIPO.int. And you can address questions to us that way or write to the PCT information line. Then we will also get back to you. So today's topic is priority claims. How exciting. It is an important subject matter. And if you file patent applications, if you file a PCT application, it's very likely that you will actually utilize the possibility to claim priority. So what is this all about? Again, we are starting out a bit more with the basics here and not assuming that you know terribly much about the subject already. So I'm trying to keep it as straightforward as possible. So what is a priority claim? A priority claim, I guess you can look at it as a link that is being created between two applications. I mean, in our context, it's two patent applications, and which would have the effect that the second filed of those two applications would be treated for prior art purposes, and I'll explain prior art in a moment a little more, as if it had already been filed on the same date as the initial application. So for prior art purposes, both applications will be treated as if they had been filed on the same day. Now, prior art is the stock of documents and information that a patent examiner needs to go through in order to determine whether your claimed invention in your application, be that a national or a PCT application, can be considered novel, inventive, and industrial applicable. Now, the terminology under national law varies a little bit on that, but most examiners would at least look at the question of novelty and inventiveness. And in order to be able to make that determination, they need to, of course, look at what's out there in terms of information. Has anyone already disclosed the same invention in a publication, in maybe another patent application, in a technical journal, etc.? And so this is really what we consider prior art, and it's of course extremely important for anyone filing an application to be aware of the prior art, but then the examiner at the office where you filed your application will also check whether, according to them, they think that your invention is really novel. And so it's critical to know what kind of date, as of what date they will be looking at prior art and as to whether it's relevant. So clearly, when you file a patent application, anything that's disclosed after the filing of your application will not be considered relevant prior art. You were the one who filed first before someone else disclosed similar information. So whatever was disclosed after filing should not affect your right to obtain ultimately a patent. Now, in the context of priority claiming, and is what I said, that you basically can link two applications with this priority claim. it means that for both applications, as far as prior art is concerned, they will be looked at as if they had been filed on the same day. So maybe I'll quickly move to the next slide to give you a bit of a visual here. So here you see a classical timeline, a typical timeline of a PCT application, but claiming priority is actually something that works also outside of the PCT, and I'll come back to that in a moment. But I have the example here of a PCT application. So a lot of applicants start out filing a national application first. And then, as you probably know and heard already in previous presentations, it's very important that within 12 months you file your subsequent applications. In my case, it would be a PCT application. So, whether it's a PCT or a national application, that's your second application, doesn't maybe matter so much right now, but you have essentially two applications. So the first filed application and your second filed application. And if you make a valid priority claim, then for prior art purposes, both the second filed and the first filed application will be treated as if they have been filed on the filing date of the first application. So that's at month 0, if you so wish, on my timeline here. Okay, and now I'm gonna try to jump one step back. Okay, so basically this is what I already kind of explained. This is like the first point here, that the filing date of the first application counts as the date from which prior art is assessed, also for the second application. Another element of priority claiming is that if two or more individuals have actually come up with the same invention independently of each other, then usually the right to the patent at the end belongs to the person whose filing date was first or whose claim priority is the earliest. So also in this context, so you have two competing applicants on the same invention, the priority claim also becomes important as to the date that you can actually claim in your subsequent applications. So this is, again, just to highlight here the timeline of a usual PCT application with a priority link in it. So a first filed application in the US, that can often be a non-provisional application, and then followed by the PCT at 12 month filing the international application with the local receiving office. We talked about this timeline before. I don't think I need to spend so much more time on this, but obviously if you have questions later on, you can also raise them. So why do we actually have this right to claim priority? Why does this even exist? And basically, the underlying idea is it would be rather difficult for any applicant who needs protection in more than one country to more or less simultaneously file applications in all those countries where he or she would like to obtain protection. And so in order to simplify matters for applicants, the Paris Convention actually came up with this idea, and it's contained in Article 4 of the Paris Convention, that you can file in one of the member states of the Paris Convention a national application, and then follow it up within 12 months in another member state of the Paris Convention. And that allows you to make this link to claim priority to that earlier application, and therefore get the effect that I just described. So it's essentially an easier way for applicants to file applications ultimately in multiple jurisdictions without having to do so all at the very same moment. So I talked about the legal basis for claiming priority already. As I said, it's contained in Article 4 of the Paris Convention, but it's of course also something you can utilize when you file a PCT application, because PCT Article 8 actually refers to Article 4 of the Paris Convention and basically incorporates the right to claim priority into the PCT application. And the PCT specifically allows you to claim priority of an earlier national, regional, think of a European patent application, or an earlier international application. So theoretically, you could file one PCT application and then at the end of 12 months file a second PCT application and claim priority of the first filed PCT application. All of that would be possible and permissible. Moreover, the PCT has extended beyond the Paris Convention and also allows you to claim priority of an earlier application filed in a member of the World Trade Organization. Now, this is important in certain cases because whoever is a member of WTO might not necessarily be a contracting state of the Paris Convention. And I'm using the term member very specifically because there's actually not a requirement that you have to be a state in order to be a member of WTO. And so, for instance, Taiwan is a member of the WTO, and you can also under the PCT claim priority to an earlier filed application in Taiwan in a subsequent PCT application. So in rare circumstances, this distinction might become important. Another source of priority claiming and a legal basis for priority claiming is, of course, usually contained in national law. They're usually referred to as kind of internal priority claims. So you file more than one national application, but you want to link the two. In the US, the term that's often used in this connection is claiming benefit. And claiming benefit under the US law is actually quite a bit different here from what I talked about, the Paris Convention and the right to claim priority under Article 4, because really under benefit claiming, what's essential is that you have a co-pending application. For as long as you have another pending application, you can claim benefit for the purposes of the United States. That's different from the Paris Convention. So the Paris Convention, it's very important that you can only really validly claim priority if you file your second application within 12 months from the first application. So not co-pendency, but there's this 12 months important time limit to claim priority. So how do you make a priority claim? And I'm now mostly referring to the PCT, since I guess this is a webinar about the PCT. So when you file your PCT application and you would like to make a priority claim to an earlier filed, let's say, national application in one of the countries of the Paris Convention, then essentially you need to include in the PCT request form three pieces of information. That is the filing date of the earlier application, the application number that was given to you by the Office of First Filing, and then also the name of the office. But usually it's the country of where you filed the national application. If it's a regional application, the regional office, and if the earlier application was a PCT, it should be the PCT receiving office that you indicate. So by simply including these three pieces of information, you have a priority claim in a PCT application. Now, keep in mind, this is only the formalities of the priority claim. This does not necessarily say whether you have a valid priority claim substantively or a particularly good priority claim, because the receiving offices in the PCT system will only check these formalities that I just described. So whether you indicated this information and whether you also have a priority claim that is not older than 12 months from the filing date of your PCT application. Whether certain substantive conditions for the priority claim are met, that will be only looked at by designated offices in the national phase. There's a little bit of looking at it by the International Searching Authority and Preliminary Examining Authority, but let's say for simplification purposes, predominantly this is a question to be decided by the designated offices later on. Now, once you make a priority claim in a PCT application, and I think I talked about the priority date before in another webinar when we talked about time limits. So the filing date of your priority claim will become the priority date. Now, this is very important in the PCT because a lot of time limits are calculated from the priority date. So it's critically important, of course, that you know the filing date of your earlier application if you do make such a priority claim. If you have multiple priority claims, the priority date becomes the earliest of those filings, of those earlier national applications or regional applications that you filed and of which you claim priority in the PCT. If you do not have a priority claim, which of course is also possible, that's usually referred to as PCT as a first filing. In that case, the international filing date will be your priority date and serve as a basis to calculate all the time limits based on the priority date. So obviously, making a priority claim and filing a PCT application, we always recommend that you use ideally ePCT or another filing software provided by your local receiving office that's hopefully as intelligent as ePCT in providing you feedback as you enter data on priority claims. So the ePCT system does that. So you enter certain data, it will automatically check, is your priority claim older than 12 months? Then you'll get this flag to you. Also, at least to a certain degree, as the system is able to recognize it, they will compare, is that a likely correct earlier application number? Does that fit with the information that we have on application numbers from the particular office that you claim that you filed your earlier application with? So the system or the ePCT system will check various things and give you instantaneous feedback if there is a potential error with your priority claim. It will flag it, and then you can take another look and you can hopefully fix a problem. I mean, believe me, I have filled in mostly not real, but mock paper PCT applications for training purposes. And I have noticed I tend to really often make a mistake when indicating priority claim information because the numbers are usually long. You have to be very careful with the date to get this right. And so it's quite easy to make a mistake. We generally also recommend, it's one of the areas where it's really helpful if you have a colleague to double check the information that you put into the request form, just to make sure this is right. I'll come to the question of, if you make a mistake, is it correctable? But it's always better to get this right from the start. Now, I'm saying all this on a slide that actually talks about something else. What I do want to say on this slide is that the Paris Convention actually already contains a requirement that if you make a priority claim, offices, the second filing, as we call them, so the office where you file your second application, can require that you provide them a copy of the earlier filed application. That's what we consider the priority document, a certified copy of that earlier application. And why do offices need that? Well, basically, they need to check whether you actually did file an earlier application on a particular claim, on a particular date, as you seem to claim. And then also they need to look at the contents. We haven't really discussed the substance of priority claims in this presentation, but I think it's apparent probably to everyone that if your earlier application relates to a chair and your PCT application relates to a table, it will be relatively difficult to convince the Office of Second Filing that this is a substantively relevant priority claim. Formally, if you follow what I said before, you'll have your priority claim, that's all fine. But if you come then to the national office and they take a closer look at your priority claim, they might have an issue if the subject matter is really something completely different than what you have in your earlier and what you have in your subsequent application. So this is why designated offices of second filing need a priority document. And the easiest way to get the priority document into the system is through the DAS system, the Digital Access System. It's basically a system where we link between offices and we can pull documents from other offices which they make available in databases that we have access to. What exactly the steps are that you need to do in order to get your first application into the DAS system depends a little bit on the office with which you filed that earlier application with. Some offices will automatically include it in the DAS system and send you an access code. Others require that you fill in a form and specifically ask for your application to be included. So this is something you need to check a little bit with your Office of First Filing. What are the requirements in order to get my application into the DAS system? Now, let's suppose you did all the steps you need to do, then you should be receiving an access code, and that's the code you can then include in the request form as you file your PCT application. If you don't have the code at that stage, you also have time to furnish it later. But of course, the easiest if you already have that code and you enter that code as you submit your PCT application. If you use ePCT and if you enter a code, the system will actually automatically try to validate whether this is a document that we have access to, and you will get instantaneous feedback if we have access that everything should be fine and you complied with the requirement to furnish a priority document. So that's really nice reassurance for any applicant filling in a request form, and another reason why we strongly recommend the use of ePCT. I know, of course, there's probably also some colleagues from European countries listening to this, so you might not necessarily be using ePCT, but you're hopefully using the online tool from the EPO 2.0, I think it's called, and that actually has a plugin which is essentially ePCT. So when you file a PCT application through the EPO tool, you're essentially also using ePCT. Okay, if you can't use the DAS system because maybe your Office of First Filing is not yet part of the DAS system, and that can happen depending on where you filed your earlier application, then you still have the opportunity to request your receiving office to possibly prepare and transmit the priority document. That's the second best option. It only works in a case where the earlier application was filed with the same office that you're now filing the PCT application with. If it's a different office, you cannot ask the receiving office of the PCT to obtain that document from the Office of First Filing. And in that latter case, if DAS doesn't work, it's not the same office, you need to go back to the Office of First Filing and either get a accepted electronic copy of the priority document or, sadly, a paper copy of that earlier application and furnish it. We say either to the RO or the IB. Usually I would recommend, if at all possible, furnish it directly to the International Bureau, especially if it's a paper copy, because a lot of offices don't like to or are not very good at handling these kind of paper priority documents. Once you have furnished a priority document, it will be the responsibility of the International Bureau to make copies of this priority document and provide it to all the designated offices. So you really only need to ever make sure that one priority document is uploaded into the system through DIS, for instance, and then basically the rest will be taken care of by the International Bureau. So I promised I would get to the point about correcting a priority claim, and at the same time, we can also talk about adding a priority claim. Both is fortunately possible under the PCT. However, very strict time limits apply. So this is covered by PCT Rule 26 bis.1a, and admittedly, and I probably have said this before, this is one of the most complicated time limits under the PCT system. So I think the easy way to remember is you always have 4 months from the time of filing of your international application, from your international filing date, to either correct or add a priority claim under the PCT system. And it's super important, if you do make a mistake, that you try to at least do it within these 4 months, because then it will be accepted by the receiving office, or if you file it with us, by the International Bureau, and then also designated offices will accept it. If you do not meet this time limit, there is considerable doubt as to whether you can still fix this priority claim in the national phase. Basically, designated offices, if you're outside the time limit, do not have to accept it. They might accept it if their national law provides for it, but basically they're not obliged under the PCT to accept a late correction or a late addition if you're outside of that time limit. And that's why I'm stressing this so much, that really, if you do need to fix a problem or you overlook to include a priority claim, do it within 4 months from the international filing date. I'm referring here to some of the details of the rule, which basically sometimes also give you more time. So the saying goes, as we like to say, you have always 4, but sometimes more. So if there is a 16-month time limit from the earliest priority date, which expires later than the 4 months, that 16-month time limit could be the time limit that applies in your case. Now, that 16-month time limit really is in practice only relevant if you do not wait until the very end of the priority period to file your PCT. Because if you wait until the very end of the priority period, you're at 12 months anyway, plus 4 months, you're at 16 months. So basically, the 4 months and the 16 months will very likely expire almost on the same day. However, if you file your PCT application slightly earlier than at the very end of the priority period, which of course is a good thing to do, then you might actually, in certain circumstances, have a slightly longer time limit based on the 16-month time limit from the earliest priority date. What do I mean with the earliest priority date in this case? So this basically means either the date that you incorrectly indicated in the request form or the one you should have indicated. Between those two, it's the one which expires earlier. So it's the earliest of those priority dates. As I said, it's pretty complex and definitely one of the most complicated time limits under the PCT. So don't feel too bad if you don't get it immediately. There is also an online time limit calculator on our website, so you can always use that, enter the relevant dates, and then it will actually tell you what is the time limit within which you could still correct this priority claim or add a priority claim. So if you do make a mistake, you can come in yourself with a correction, and it's of course great if you notice it within 4 months. The RO or the IB will take a look at your application, and if they notice that something is apparently incorrect with your priority claim, they will invite you to correct. So the RO will send out PCT RO 110 and the IB PCT IB 316. If you get one of these forums, it's really important that you take a close look as to what might be the matter and to check whether you still have the possibility to timely request a correction or an addition of a priority claim. Of course, for receiving office and for us, it's difficult sometimes to know that there's something wrong with a priority claim. Imagine the case that there's a little digit wrong in the priority number. That's not something that ROs or the IB will very easily detect. So there might be cases where you will not get an invitation, and that's unfortunate. But it also, again, goes back to the point that you really from the start need to be very careful when you add this information into the PCT request form. It's difficult, as I said before, to add or correct a priority claim in the national phase. Some national laws provide for it. In the US, it's relatively straightforward and easy to do. In other countries, it can be extremely difficult or close to impossible. So it's really important that you try to get the formalities right from the start or correct them at least within the 4 months that I described before. Can you withdraw a priority claim? Well, maybe that begs the question, why on earth would you do that? And I would like to caution you before even thinking about withdrawing a priority claim that you really need to be very careful about that. If you withdraw a priority claim, then basically the protection that I talked about earlier, your protection against relevant prior art, will fall away with the priority claim that you have just withdrawn. So if there is relevant prior art out there and with a priority claim you were actually protected against it, then basically all of a sudden you would be exposed to that relevant prior art. And this might mean that maybe you can't actually obtain a patent anymore because the office will find documents which are relevant and then say, oh, sorry, it's already out there. And keep in mind, there can also be your own disclosure. This is something that applicants sometimes don't realize. They think, prior art is only what other people have come up with and disclosed, but it can actually also be your own disclosure. So, you're really eager to show your invention at, a conference, and boom, you are creating prior art, and you need to be really careful about that. Always file before you do that, or at least your national application of which you then can claim priority should always be in place before you show yourself or you describe your invention in a technical journal, etc. There are, however, sometimes applicants who come to us close to 30 months from the priority date and say, well, we really need a little more time to enter national phase. And they ask us, can't I withdraw the priority claim to gain additional time? And yes, this is possible. If you withdraw a priority claim, then any time limits which haven't yet expired at that moment will be recalculated based on a new earliest priority date. So if you have multiple priority claims, will be the second priority claim in your PCT. If you only have a single priority claim, it would be the priority date would become the international filing date. And so the 30 months time limit could also be recalculated, potentially be extended up to a year's period. That sounds really tempting. But again, it comes with the risk that you will be exposed to relevant prior art. So gaining additional time, as tempting as it may sound, it might also be devastating in terms of obtaining a patent later on. So be really, really careful about that. And in practice, to be honest, it doesn't happen very often. So it would be a very rare situation that someone would try to withdraw a priority claim. So what if I miss to file my PCT application within 12 months? So as you probably all know by now, it's critical to file your subsequent applications within 12 months. So this is what the Paris Convention provides for. You can claim priority if you file your subsequent application within 12 months from your first filing. And that applies equally to PCT applications. So keeping within the 12 months is super important. Now, a couple of things to think about if you are about to miss the priority period, this 12-month window. Keep in mind, midnight is not midnight everywhere. It sounds a bit silly, but what we're trying to say here, think of time zone. So midnight Geneva time is not midnight, I don't know, West Coast time in the US. So even though maybe I shouldn't mention the West Coast, because I think for patent filings, what matters is more the time in Washington D.C. So in any event, but you get the image. So if you missed 12 o'clock midnight in your local office, maybe you still have the opportunity to file with an office that is still open on that day and will then give you a filing date still on that same day, meaning that you can still validly claim priority. It's sometimes a little bit complex to get to that point, and you might need to add a co-applicant so that you're able to file with such an office. ePCT is also not particularly helpful if you have a set of applicants, but you're trying to file with an office for that is actually not competent to receive your application. The system blocks you, so you have to think of some workarounds in ePCT if you want to use ePCT. But it's at least a consideration to make if you really just missed the 12 o'clock midnight time limit. A little more extreme would be the case where you look actually for offices that were closed on the last day of the priority period, maybe not your home office, with which you usually file, but maybe some other office has a public holiday on the last day of the priority period. And if you were able to file with that office on the next day when they're open for business again, that would be acceptable under the Paris Convention to still timely file your subsequent application and claim priority. We actually even publish lists of office close dates on our website. So if you have missed a priority period by 1 day, it might be worth checking, was there an office who potentially was closed on the last day of the priority period. The last resort is to request restoration of the priority right, and that might be probably the most straightforward procedure to follow in such cases. So a couple of years back, the PCT member states agreed to allow applicants in a case where they missed a priority period to still restore the priority right if at least the PCT application was filed not later than 2 months from the end of the priority period. So if you have a really old priority claim, you cannot request a restoration of the priority right. It has to be filed at least within 2 months from the end of the priority period to even be eligible for restoration of the priority right. However, it's not just a simple request, hey, I would like to restore. You will have to make some kind of a showing that you either missed the priority period unintentional or in spite of due care. Unintentional is relatively easy to show. It's basically saying I accidentally did not file in time. Due care is more difficult to show. Due care requires that you show that you acted like a careful agent or applicant and that you usually would not miss this priority period. And it was an individual error happened on a particular day that led to the missing of the priority period. So more need for a detailed explanation, and of course also more of a possibility that your explanation will not be accepted by the receiving office. By the way, you can request restoration either with the receiving office or with the designated office. So you can also wait until you enter the national phase to ask for your priority right to be restored. Requires, of course, that the office that you're looking at accepts the restoration of the priority right, and not all designated offices currently accept restoration of the priority right. So you have to be a little bit careful with that. And then usually we recommend that you try to go for the due care standard if you request restoration of the priority right, because offices only have to accept the due care standard in the national phase if they apply the higher due care standard. So let's say you only got your priority claim restored under the unintentional, the lower standard, the oops, sorry, I missed the priority period. Then a national office that applies the higher standard is not obliged to accept the decision by the receiving office only based on the unintentional standard. And that's why it's always better and more helpful to go for the higher standard. So for instance, an office like the EPO that applies the due care standard would then also accept a restored priority right. It's a suboptimal solution in the sense, and that's why I talked about midnight is not midnight everywhere and office closed days, because restoration will not be accepted by all designated offices. If you find an office closed date, that in principle should be accepted by all offices. So it's definitely worth to look into this if it happens. But of course, I hope in your practice, when you file or you will in the future file PCT application, it will not happen that you miss the priority period. It's really one of these time limits that's super important and that, really should be noted down with all care possible so that you don't end up accidentally missing the priority period. All right, and that takes me to the end of the presentation. I just wanted to highlight here at the end that there are resources on our website in 10 publication languages of the PCT, so take a look. There's also more training material on our website. Incidentally, if you're interested in us organizing something specifically for you and your colleagues in terms of a webinar, for instance, you can also always reach out to us and file such a request with us. And overall and generally, of course, we would invite you to reach out to us with any questions about the PCT. I've noted down here the contact details of the PCT information line. It's our help desk, and they can also always pass it on to the relevant colleagues if it's not for them. So I will, I think, stop sharing, and I will try to look at if there are any questions. Okay, so I'm just gonna start going through some of these questions as I see them in the Q&A. So the first one is, can you file multiple national applications and then claim priority from the earliest application? Yes, absolutely. And applicants do this on a regular basis. So they don't just file one earlier national application, but multiple. The most important thing to remember here, though, is your last application, in order to claim priority of everything that you filed earlier, needs to be within 12 months from the filing date of your very first application. If you respect that and you have multiple priority claims, that's all possible, but things get very complicated if you miss to file subsequent applications within 12 months from your earlier application. Okay, sorry, and I think there was another question trying to clarify this more, but I think I did answer that. So if I didn't, then please type in again that it wasn't clear. Could you please share details of publication of each of the kind codes for a PCT, such as A1 is the first, A2? So basically, I mean, this is a different topic here, but A1, A2, A3 publications is actually a kind code that describes whether we are publishing, in the case of a PCT application with or not a search report. So an A1 publication is a international application for which a search report has been established, and therefore we are able to publish both the application and the search report at the same time. If it's an A2 publication, it's an application without a search report. And if it's an A3 publication, it's a late search report that we are now republishing. And you need to read the A3 publication together with the A2 publication, and then you get the whole picture of the application plus the search report. Okay, when you say some countries that do not provide provisions accepting filing outside the 12 month, do you mean after the 4 months or after those 15 months? Oh my goodness, I'm not sure what I said in this context anymore. But your question is now not entirely clear to me. So basically, the Paris Convention provides the right for applicants to claim priority if they file their subsequent application in 12 months. And that's the standard that all member states of the Paris Convention need to accept. So there's really no exception to that, and all member states should accept it. The 16 months and the 4 months is actually more about correcting priority claims. So that's somewhat different. And now I actually lost your question, so I'm not really sure. I think it was already moved on. So I hope you got some answer to that. Are the PCT recognized in the national country? That's a very broad question, and I'm not 100% sure how you mean this. So if you are a member state of the PCT, then basically, if a PCT application is filed, the filing of the application should be treated just like a regular national application. So the answer to your question is yes, but maybe your question also meant to ask whether you could, in a national application, claim priority of an earlier international application. Now that depends a little bit on the country you're talking about, but if the country is part of the Paris Convention, then yes, clearly that would work, because the PCT is in a way a bundle of national applications, and clearly at least one of the states designated in the PCT is a Paris Convention country. That's obvious, and therefore the country, the national office where you then claim priority to the PCT, needs to recognize it under the Paris Convention. So yes, that would work. If there's time, could you comment on the following? How does the ISA actually check about a priority claim in practice? Yeah, very good question. I think essentially the answer to that is they don't really check. Because in the vast majority of cases, the priority document is not yet available to the office, or even if it's the same office, you might have filed the earlier application with the same office, then they might not be in the possession of the priority document at the time when they need to do the search. So very, very likely, and I would say in the vast majority of cases, the ISA doesn't actually look at the priority claim, the details of the priority claim. Different in the Chapter 2 procedure, which of course is also later. There, the IPA would potentially look at whether you have a valid priority claim and could comment on the validity of the priority claim in the IPRP Chapter 2. Question 2, how is the first application criteria Paris Convention Article 14.4c assessed? For instance, does the ISA search for earlier applications of the same applicant to assess this criteria? Oh, this is getting highly complex now. I think maybe it might be better if I pick up that question after the event and try to answer that directly to you in an email. I'm just trying to think if I can say something quickly on this. Search for earlier. I mean, I think I'm not sure if that's what you're getting at, but anything prior art, I mean, is usually defined as anything published anywhere in the world. It used to be by way of written disclosure. Now where it's actually also in the PCT by way of any disclosure. And so if it's the disclosure itself by the applicant, that of course could also in itself be relevant prior art, and the ISA would have to also look at what the applicant him or herself has made available to the public. But it wouldn't only be that, it would also be what third parties have made available to the public. So it's maybe a little bit of an answer to your question, but it's probably not complete. So maybe do come back to us if you want some more on this. If requesting restoration of the priority right with a designated office, e.g. the EPO, would you request early entry into the regional European phase to do so as soon as possible? I don't think I would necessarily recommend that. I mean, depending on who your receiving office is, you can very much request restoration of your priority right with the receiving office under the higher due care standard. And that would then also be something the EPO would accept as you enter the national phase. There's not necessarily a need to enter early because in a way you're hoping to restore the priority right. It should be fine to request restoration if you have a solid case and really a convincing case to come to a positive decision on restoration. So, I mean, basically entering the national phase early, just to come back to this question, I would only consider doing that if you're actually not certain. No, wait a second, that's another case. Yes, entering the national phase early, I would recommend in a case where you try to make a priority claim, but for whatever reason, your priority claim was considered not to have been made. And then theoretically, you could argue, well, now I have 1 more year time to enter national phase, but it's going to be difficult in such a scenario to enter 1 year later and then argue with the national office to still accept your priority claim. So for me, that would be a case where I would say enter early as if your priority claim was valid and then try to restore your priority claim in the national phase. That would at least increase your chances of being successful with restoring your priority claim in the national phase. But it's a slightly different scenario from requesting restoration of the priority right, as I just explained before. So if you withdraw a priority claim, you cannot claim priority to that same priority application. Yes, so basically, if you withdraw a priority claim, then I guess if you're still within the time limit of 4 months, you can re-add the priority claim. That would theoretically be possible, but that's usually not what applicants would like to do. They withdraw a priority claim, and then essentially they no longer have a priority claim. There are changes in the PCT guidelines related to priority claims. Um, Not really to priority claims. As of lately, nothing really has changed there, so I'm not quite sure where this question comes from or what you have in mind. But no, as of recently, there has not been any changes. Are there any set forms for the restoration request? And if receive a positive due care decision in the PCT application, are downstream national stage offices obliged to accept? Yes. So then there's no particular form that you need to use to request restoration. In the request form itself, you can already check a box. I'm requesting to restore the priority right, but you then still separately need to furnish an explanation as to why you missed the priority period. And of course, then there are forms that the offices will use when they decide on the request for restoration. And let's say you are able to convince the RO to accept the due care standard, the higher standard, then all national offices applying restoration in general would need to accept that decision. As I said earlier, there's offices like the Republic of Korea that currently does not yet accept restoration of the priority right. They're in the process of changing their national law, and they will hopefully in the near future accept restoration of the priority right also for the Republic of Korea. But at the moment they don't. So in these offices, of course, even if you have a positive decision, it's not going to work. But all other offices that do accept restoration in principle should accept a positive due care decision. Is there a webinar on finding priority codes via ePCT? I don't know if there is actually any particular webinar on that, but this is maybe something we can look into and try to find information for you on that if you need more. If you missed the PCT filing in the 12-month period and you filed this directly via ePCT at WIPO with the sentence unintentional, including the request to restore the priority, will you receive a confirmation letter that they accepted this? So if you only want to go for unintentional, and if you already did somewhere indicate that you unintentionally missed the priority period, very likely we will take this as a request under the unintentional standard only if it's our receiving office, let's say, and we would then issue form 159 accepting your request to restore the priority right. But of course, you won't get it under the due care standard. There was a little bit of a discussion in the early days of restoration of the priority right if just mentioning the word unintentional was good enough under the unintentional standard. But at least our practice has been if someone says I unintentionally missed a priority period, that this would be good enough under the standard. Or other webinars on WIPO DAS services. Again, we have to check whether something already exists, and we'll point that out to you, or otherwise we'll take it as a suggestion, as a proposal to organize a webinar on DAS. Can an international application claim priority of a national application that has already claimed another national application? So basically, you file one earlier application in country A, another one in country B, and then you file a PCT. Yes, that's also possible. As long as the PCT is within 12 months of all these earlier applications, that should in principle be fine. Does the PCT recognize non-prejudicial disclosure or grace periods? So PCT actually does not have any provisions that would govern this, and it would be a question of national law whether you could benefit from a grace period. So the PCT doesn't offer this, and it would be down to national law. And here's also, I guess, the difficulty. in some countries you have certain grace periods, and in others you don't. So even if you could benefit from this in one country, you might not be able to benefit from a grace period in another country. So be very careful. Don't rely on the possibility of a grace period in one country that you're aware of and assume they will equally be accepted in other countries. And that's, as much as I can say about that. It just simply varies too much from one country to another. Okay, I think I'm gonna skip ahead to the next one. Okay, we're getting there. We're getting to the end of this show too. In the following scenario, okay, this could be complicated. US application filed in 2022, identical PCT application claim priority of the US earlier application filed with the EPO as RO, so a PCT application on, okay, 1 year later, but basically 1 day plus because the last year the priority period was actually a close date in the EPO. And then the question, does the USPTO, which has not closed, yes, have to accept the priority claim? Yes, so basically under the Paris Convention, and again, this is fundamentally covered by the Paris Convention, if an office is not open for business, and I forgot right now the exact wording of the Paris Convention, uh, then the applicant has until the next working day when the office is open again to receive applications to file the subsequent application. This is applied in a like manner to PCT applications. So if you file your PCT application with a receiving office that happens to be closed on the last day of the priority period, but you file on the next day when the office is open again to receive applications, then the receiving office will accept such a priority claim as timely filed, and then all offices downstream should, in principle, accept also such a priority claim. Now, I'm using the word should because it's ultimately a definition or an interpretation of the Paris Convention, and it's up to the member states of the Paris Convention and the courts in the individual countries to ultimately rule on questions as the validity of the priority claim under the Paris Convention as contained in the Paris Convention. So, I think to our knowledge, in practice, this has never caused a problem as far as we can tell. But to be fair, we have to say ultimately it would be a question that would be ruled by a national court who's competent to rule on the matter. And so, yes, with that little bit disclaimer inside, I would say yes, that should be fine. And Carl reminded me that there is a PCT declaration number 5. That's absolutely right. There's a declaration on non-prejudicial disclosure, but that's just a declaration. And whether you can actually then take advantage of a grace period, again, still very much depends on the country you're talking about. So let's say in one country you can publish something in a technical journal, and if you file your patent application within 6 months from the disclosure in this technical journal, for that particular jurisdiction, the national law says that's fine. Your own publication cannot be held against you. But that does not apply in another contracting state, like the EPO, for instance. They would not recognize such a non-prejudicial disclosure in a technical journal because they don't know this in their regional law. So you might be fine in a country like Japan, which I think knows this, but it might not be sufficient for countries or for regions like the EPO. Oh my, the questions are not over yet. As I'm answering, there are more coming in. Okay, there's one more here. So our firm has been experienced some issues uploading electronic copies of US priority documents in ePCT. We have been receiving an error stating the document is not signed. Do you have any feedback or any Are you aware of common issues we may be overlooking? The document is being uploaded directly off the CD-ROM provided by the USPTO. Yeah, I mean, the USPTO is one of those offices that has actually informed us that they issue priority documents on CD-ROM, electronically signed. And so in principle, this should be acceptable, and it should also be uploadable to ePCT. I have not heard about an issue that you have a problem uploading such a priority document to the to ePCT, but that's something we can look into. If you could maybe write a short email with that question to the PCT info line, then we can follow up, because I'm not sure I have necessarily your email contact details directly from Zoom here. So just to avoid that I can't reach out to you again after this event, if you could maybe send a short message to PCT info line as indicated on the last slide. So pct.infoline@wipo.int, and then we can more thoroughly check into that. And I think that exhausts the questions, as least as I see them on the screen. So I would like to thank you all very much for joining us here today. Thank you, Paula, for hosting this event. We will be coming back to you with another episode. It's going to be episode 6, I believe, where we'll talk a little more about search and preliminary examination. And well, I'm not going to make a promise as to when we're going to be airing this. So just keep a lookout on our PCT training page on our website. PCT newsletter will announce when we will be airing the next episode. And I hope very much you can join us again for the next event. So thank you very much and have a lovely rest of the day. Bye-bye.